French law firm Béjot, and I'm pleased to introduce you our panelists who will share their insights for 1 hour. So if you have questions, you can use the Q&A box or the chat box, and you can ask your question globally or individually, and you will have some time at the end of the presentation to ask your questions. So let me introduce you our panelists. For Canada, we have Fadi Amine from Miller Thomson LLP. For Dominican Republic, Jaime Angeles from AngelesPons. Hi, Jaime. For United Kingdom, we have Oliver Fairhurst from Silkin. Mexico, this is Sebastian Weinberg Garcia from Arochi and Lindner. And for the USA, we have the pleasure to have Marc Rachman from Davis+Gilbert LLP and Whitney from Frankfurt, Kurnit, Klein and Selz. So we thought that it would be interesting to present you a case study which involves two competitors, and in our scenario, a brand, an advertiser, notices false claims or illicit claims made by a competitor. But this competitor is not doing comparative advertising, and it does not make any reference to the advertiser's brand. For instance, and that's what you can see on the slides, the competitor states that it is the best or the #1, or it publishes on its website false reviews from customers, or it provides some comments or claims which are illicit in the relevant markets. So our panelists will take the role of the advertisers' lawyers, the advertisers being the plaintiff who will try and challenge the misleading claims made by this competitor. So the basis of the purpose of this presentation is to show you, to explain you how you can successfully make complaints against these misleading claims, even if you do not have any ground for comparative ad or trademark infringement, and how it can be done across jurisdiction. And depending on the market and the constraints, you can suggest some strategy. And the goal is to present you what the clients of the advertiser could expect at the very end. So we'll divide our discussion in 3 parts. First part, outset of the claim, options for bringing the claim either on self-regulatory authority where it's relevant, or maybe before courts. And then we will share some insights per jurisdiction to give you the core information you have to know in connection with this scenario. And then the outcome of the claim, for instance, whether you can be awarded monetary damages or have the ad or the claims be removed. So part 1 is the outset of the claim. I will give you some insight from France, and then I will ask some questions to our panelists. In France, for instance, you have several options. For instance, if you want to damage the reputation of the competitor, you can bring a claim in front of the jury of the French self-regulatory authority. If you, for instance, if you want to get awarded monetary damages, you have to go before civil courts, in particular commercial courts, when it deals with two competitors. And another option would be to file a claim with the Competition and Consumer Authority, which will take the decision or not to bring investigation against this competitor. And if in the end the claim is deemed relevant, the Competition Authority is able to share the matter with the French prosecutor, who will decide to launch a criminal lawsuit. So it's interesting, but in the end, in this very specific instant, the plaintiff, the advertiser, has no control over the claim, which in the end will be dealt with by the Competition and Consumer Authority. So are there many options available in Canada, Fadi? Can you share some insight about your country?
Thank you, Caroline. Yes, so we have several options in Canada that are available. And when clients come to see me to explore these options, the first thing, obviously, is I want to know is how aggressive do they want to be and how public do they want to be? And also, what type of practices do they do? Because some of these options may trigger possibly an industry investigation rather than an investigation into a person or into a company. So the three options that are available, starting from the least aggressive, I guess, to the most aggressive, would be, filing a complaint with Ad Standards. Ad Standards Canada, it's a self-regulatory body for a breach of the Canadian Code of Advertising Standards. They have an advertising dispute procedure, which, if accepted, will be adjudicated by an ad dispute panel. That we can get into it later on, but it's actually a confidential process. The next possibility is to file a complaint with the Competition Bureau based on false or misleading representations and deceptive marketing practices under the Competition Act. And the Bureau can refer matters to the Competition Tribunal, the Federal Court, or the Superior Court of Appeals based on the civil regime of the Act. The third possibility is to file a lawsuit at personally before the Federal Court or a Superior Court of a province, also alleging violation of Competition Act provisions on false and misleading advertising. But that's a civil suit between competitors. It's much rarer and frankly almost never happens.
Okay, thank you. And Jaime, do you have similar options in Dominican Republic? You are on mute.
Sorry. We have almost the same options as France, because, for example, we do not have a self-regulatory body for advertising issues. That's that's something not convenient. But we do have civil courts. The problem with the civil courts is how long you want me the process. The last one we were in a litigation. It took more than 6 years to be resolved. Obviously, at the end there was nothing to be resolved. We do have also a competition body, which is called Pro Competencia, and they do have some kind of practice on these kind of things. We can talk later on what is what we can expect from there. And also we have a consumer protection law that has a consumer protection agency, and the question will be, as in Canada, how how aggressive do you want to be, and do you want the advertising to go down and to be stopped? That's an option that we have to see in all three categories.
Okay, thank you, Jaime. And how would you handle this dispute in the UK, Oliver?
Yes, so assuming no use of a trademark or copyright or even a reference, so there could be a sort of a route if there was an implicit reference. But if we assume there's just no comparative element of it, then really the main options are the self-regulatory route. So the Advertising Standards Authority, the ASA, is the main route here. And we'd be alleging a breach of a relevant code or relevant provision in the Code of Practice. That is broadly similar to other jurisdictions, and a lot of it flows from European case law and still applies, I should say, post-Brexit. The other option through the courts is much more limited in the UK. There's not really a run off to court and say that something is breaching a consumer protection provision here, because we have specified regulators that are responsible for enforcing those. there is an option to go to seek a declaration from the court, but there's quite limited case law on that. And the declaration would be that the ad was misleading, and similarly to Canada, you can speak to the competition regulator, the Competition Markets Authority, which could investigate, but although it tends to only do so if it's something that it might be interested in at that particular time. So influencer marketing or greenwashing is another one that's important at the moment. Now, none of them are going to give rise to damages. Otherwise, a trespass on the later point. And the only one that would give rise to a court order requiring something, some ad be stopped from being used, would be that second one, the seeking a declaration to say that the claim is misleading. But that is very rare, and for the most part, most complainants would go down the ASA self-regulatory route.
Okay, thank you, Oliver. And how would you, would you recommend for the US, Marc and Craig? This is huge market, so.
I'll start off and then I'll let Craig finish. In the US, there's really typically two choices if we're talking about challenging a competitor's advertising claim. The first is the NAD, which is a self-regulatory body. It stands for the National Advertising Division. It's a division of the Better Business Bureau. It's funded by its members, who are typically part of the advertising industry. It's not a government body, and it's a voluntary process, which means that both parties have to agree to proceed before the NAD. If the advertiser who's being challenged does not participate, the NAD's only recourse is to refer the matter to the Federal Trade Commission, the FTC, and you cannot seek monetary damages before the NAD. It's just for injunctive relief. I'll let Craig now talk about the other option.
Yes, thanks, Marc. So other than NAD route, which is certainly an attractive option for certain purposes, the other typical path would be to file a lawsuit in court. I guess unlike what Fadi had said with Canada, this is not uncommon in the U.S. I don't know what the numbers are compared to NAD, but it's pretty robust. The federal court lawsuits for false advertising claims. There's the primary statute under which people bring claims in federal court for competitors. Meanwhile, we're just talking about competitor claims, which would be different if you're a consumer, which is a whole other discussion. It would be the Lanham Act, which is the federal law that governs trademarks and false advertising, etc. There's also state laws that could be utilized. They're generally known as unfair and deceptive acts and practices, or UDAP statutes. There's different ones in different states. Some states don't have them at all. Some states rely on just common law theories. But you can bring those as well as Lanham Act claims, or you can bring them instead. There might be strategic reasons for just bringing those state laws instead of federal laws. But your typical route is a Lanham Act claim in federal court. And later on, we'll discuss some of the advantages and nuances of doing that.
Okay, thank you, Craig.
If I may, just a quick, Sebastian, my experience is that most companies that will face these types of complaints in Canada will litigate in the US, and whatever happens in the US will eventually percolate and apply it in Canada without litigation. So I'm happy for this litigation to happen in the States.
Okay, thank you.
Well, as a litigator, maybe so are we. I don't know.
Good to know. And what about you, Sebastian? What are the options in your country?
Thank you. Well, in Mexico, there are three main options to attend misleading advertising issues. The action to be taken will depend in two factors. what is the client looking for? If it's, for example, monetary damages or the elimination of the ad campaign, and what are the rights owned by the client. Once we have considered these two things, the actions available are IP, civil, and regulatory. The IP action would be carried out before the Mexican PTO. It's important to consider that in order to carry out this kind of action, the client would need to have a right, for example, trademark registration that's been affected by these unfair practices. And in this particular case, monetary damages would not be awarded. Now, as a second line of action, a civil procedure against the competitor for unfair commercial practices could be initiated. If monetary damages are intended, this would be like the best way to obtain them. And finally, as a third option, we have a claim before the Consumer Protection Agency. The problem with this line of action is the party filing the claim would not be directly involved in the procedure, being that once the agency received the claim, it will unilaterally initiate the process to determine if the competitor's actions could be considered as misleading advertising, and no one could intervene directly in the process. But I will be explaining this concept in detail.
Yeah. Okay, thank you. So now we'll move and discuss some insights, and there is some specifics regarding these actions that could be brought in your respective countries. As far as France is concerned, the self-regulatory system and the complaint which could be filed with the French SRO's jury offers a key procedural advantage, because it is for the advertiser to prove that its advertising complies with the SRO guidelines at the time of the publication or the broadcast of the ad, as opposed to what happens in courts, where the plaintiff must prove that the advertiser made an illicit claim or a misleading claim, so that the claim is not true, which is a bit tricky sometimes to prove the other way around. And so before the jury, you just have to quote the relevant articles of the recommendations guidelines which have been violated. And it is the jury which will in the end assess whether the advertiser has evidence that its claim was true. For instance, if it claimed that it was the number one, the advertiser will have to prove that it is actually the competitor, the defendant will have to prove that it is actually the number one on the market. And if a lawsuit is brought in France before civil courts, commercial courts, the plaintiff would have to prove a fault, wrongful misconduct, damages like loss of sales or loss of customers, and causal link between them. So sometimes it's a bit tricky to try and prove that there is a link between the litigious claim and the loss of sales or the loss of consumers. And so I would like to hear you, Fadi, about Canada. Do you have some insights? Are there many conditions to be met to succeed in your country?
Right. Obviously, there's law is a very procedural thing. So starting with ad standards, as I said, it's a self-regulatory body. It's an industry. It's not government. It's not a governmental body. There are three requirements in order for ad standards to accept the complaint. The first requirement is the most interesting, I think. So ad standards must be satisfied that the complaining party, the complainant advertiser, has not succeeded in a good faith attempt to resolve the dispute directly with the defendant advertiser. So, you need to reach out and say, hey, there's a problem with your advertising. If that occurs, Then ad standards must be of the opinion that there are reasonable grounds to proceed with the complaint. And then obviously there has to be a fee paid, which is non-refundable. Either party may ask ad standards to convene a voluntary, not mandatory resolution meeting between the two advertisers. There will be no live hearings by the panel. The only materials the panel will consider in their deliberation are the written submissions of the advertisers. The panel's decision, including whether or not it will accept the complaint, is final. There's no appeal from it. And most importantly, the advertisers may not disclose or discuss publicly the decision, except within their respective organizations. The identity of the advertisers and members of the panel may not be disclosed by ad standards or the advertisers. It's a relatively quick, uncomplicated, practical, informal, and cost-effective method of resolving advertising disputes in a confidential forum outside of the judicial system. And I can tell you that a lot of the times, advertisers will choose to go that route. The second option is complaint with the Competition Bureau. So it's important to note that the Competition Bureau is not a consumer protection agency. It's a federal body. It's not a provincial body. Each province has its own consumer protection laws that sort of has some similar provisions, but only consumers can use them. The Competition Bureau is the only law where an advertiser, non-consumer, can use in order to sort of affect the same type of change. So the Competition Bureau is not a consumer protections agency, and it cannot act on your behalf or to obtain reimbursement or to settle a dispute between two parties. It's a law enforcement agency headed by the Commissioner of Competition, and it is responsible for the administration and enforcement of the Act, obviously. When receiving a complaint, the Competition Bureau may decide not to act on the complaint, commence an informal investigation, or initiate a formal inquiry. The Competition Bureau conducts its investigations in private and keeps confidential the identity of the source and the information provided. So if you're an advertiser who's concerned about something, that may also be a sort of safe way for you to go. However, if someone has important evidence about a contravention under the Act, that person may be asked to testify in court if it goes there. So you have to be aware of it. I will say a few words about a civil claim. Obviously, the civil claim is obvious. It's the same burden as in any civil claim. So all the elements must be proven on a balance of probabilities. Before moving on, just one last thing in Canada, which may be different than in the States, is the standard by which you decide whether marketing is false or deceptive. We have a case in 2012, which is Time versus Richard versus Time Inc., Time magazine. I was on it. It went all the way to the Supreme Court of Canada. And in that decision on a provincial consumer law, the court has said that the consumer, it's an objective standard and he has to be credulous and inexperienced. Credulous and inexperienced consumer, which is sort of different than the prevailing standard, which is sort of a medium type of consumer that is not a moron in a hurry, which is a famous American case that I cited, and unfortunately the Supreme Court didn't follow me on. And since that decision, the standard has sort of fluctuated in Canada, and a lot of the time they use this standard in order to come up with deceptive and marketing decisions that sometimes are a little surprising.
Thank you, Fadi. And what about you, Jaime? How does it work in your country?
In the Dominican Republic, if you want the advertising to be stopped, you have to go through the civil courts because they're and ask for an injunction or file for an injunction, or you might go through the Consumer Protection Agency that they have the authority to stop the advertising. And there has been several precedents of the Consumer Protection Agency stopping the advertising, false advertising. If you go through Procompetencia, that is the antitrust agency, you only will have a decision that says, yes, there is an unfair competition on that, but there will be no halt on the advertising, and there might be some calculation on the damages, but they will not impose damages. So at the end, you have a very lengthy process through the civil litigation. As a matter of fact, I forgot to mention before, never it's a criminal offense. So there is no authority to pass these cases to the prosecutor. Never in the Dominican Republic. And so also you have the three ways to go, but only damages in the civil courts.
Okay, the same as in France, actually. And Oliver, what are the main characteristics? Do you have a possibility? You said damages is most likely no, but what are the main characteristics of your actions?
So, I mean, just if we went with the with the court proceedings that I mentioned, where you're seeking a declaration, that's as an unusual approach. It's not commonly done in advertising. You file a claim, you would be seeking disclosure, which is at least is a helpful attribute of the UK system, but realistically, it's very unlikely. In terms of the ASA procedure, so that's a self-regulatory one, that's the most common. A competitor that's challenging advertising, so it doesn't have to be comparative advertising, but when a competitor is challenging its competitor's advertising, it would need to write a letter. It can be quite informal, and quite often clients will deal with it themselves, so they might take a bit of advice on some of the points. And they'll send out, you need to give 5 working days, so it's not a huge amount of time. Although if the advertiser needs a bit more time to respond, it's expected that you'd give them that. You wait for that response, or at least for that time to have elapsed. You send the complaint to the ASA, you enclose that correspondence, and you say why you think it's a breach of the relevant advertising code. Then it kind of goes into a bit of a black box for a while, where the ASA will look at it. They'll work out whether or not it's something that they need to investigate, sort of a prima facie case, really. And they'll look at the advertiser as well, and whether or not there's been any undertaking given. It doesn't need to be a formal undertaking, but some form of undertaking not to continue that ad. The ASA has sort of 2 options. Then it can either do an informal resolution. So if the advertiser kind of throws their hands up and says, "Yeah, okay, but I don't think this needs to be looked at, and we're not running the ad anymore, so nothing to see here," or it might open investigation, which sounds very formal. It tends not to be very formal. Where the advertiser is asked to maybe substantiate its claim, or to explain, how it views its advertising. And if the advertiser is unable to substantiate the claim, or if the ASA just upholds the complaint, it then publishes it. And it happens every Wednesday. The press gets they get told in advance before they're made available what the decisions are, and then that means that you tend to get, so and so's ad has been banned, is how it tends to be described in the publishing copy. So the adverse PR is probably the most effective part of it. So it's certainly not confidential, but it is pretty cheap, and it's reasonably fast. The advertiser does have the opportunity to challenge it to the independent reviewer, and this is all done fairly confidentially. It's sort of not published, a lot of this, but the ultimate decisions are made public and are picked up by the press. And because it's reasonably cheap and reasonably quick compared to court proceedings, it tends to get it goes through reasonably quickly and easy, and that's quite a popular route.
Okay, thank you, Oliver. It's very interesting, and that sounds some bit different with the French system and the other system that we have described previously. So in the USA, Marc and Craig, you explained to us that there are two different types of actions to be launched, NAD and the federal court system. Can you tell us a bit more?
Sure, Caroline. I'll start and then let Craig finish off. So with an NAD challenge, as I said before, both parties have to agree to participate. If they both decide to proceed, there's three types of tracks. One is referred to as the SWIFT track. It's a single well-defined issue. So if there's only one well-defined claim in issue, you can go that route. That will allow that if you take that route, it's very fast. It could be actually in 20 business days decided, no hearing on the papers, and decided by staff attorneys who are employees of the NAD, whose job and role is to make decisions with respect to advertising issues. So they are very familiar with the advertising law, which can be a reason to go before the NAD, because if you go before a court, you potentially could get a judge who isn't as familiar with the advertising law, or if you go all the way to trial, you could get a jury who is not going to be experts in advertising law. You cannot seek preliminary injunctive relief before the NAD, so that's something to consider. So you have to wait for the ruling. It is a private proceeding, similar to Canada, except that the final ruling is public. So the what is presented before the NAD is private, but what the NAD rules becomes public, so that the public can know what the decision was with respect to the claim that was challenged. There's two other tracks. I mentioned the SWIFT track is the fast track. There's the standard track, which allows parties to put in papers as well as have a hearing before the staff attorneys. That hearing is done separately. Unlike a court proceeding, the parties present without the other party present, and you can make the advertiser whose advertising is being challenged can submit materials that are confidential even to the challenger. And then the final track is referred to as the complex track. That is for a complex multiple issues, typically including expert reports and surveys, which you can provide in an NAD proceeding. It also takes a longer period of time to decide. A standard track is usually 4 to 6 months. Complex track could be longer, but even on the long end, it is shorter than the court route, which Craig will talk about. There's no motions, there's no discovery, so it is a less expensive route to take than going to court, and which is one of the reasons why it's often used. I saw one participant had asked about whether the NAD could take any, can issue any fines or seek injunctions itself. The answer is no, but if the NAD ruling is not followed by the advertiser, the NAD will refer the matter to the Federal Trade Commission, which is a federal government organization that does have the power to fine and does have the power to seek court injunctive relief. So ultimately, it can get to that point through the NAD, but it would have to go to the FTC after the advertiser fails to comply. The last piece before I give this over to Craig to know is that you have to pay a filing fee for the NAD, which is actually significantly higher than starting a federal case. The filing fees are based upon the size of the company involved, both parties, and they can range from $8,000, which is actually high for a filing, all the way to $75,000 for a large company in a complex case. I think those are the points I wanted to raise. I'll leave the floor to Craig.
Thanks, Marc. Yeah, I'll talk a little bit about the nuances and characteristics of filing a court action, which, there are some real important differences. And, part of what Marc and I actually do is in analyzing these claims for clients is deciding where to bring it, because it really depends on your goals, the facts, the circumstances, because there's a lot of nuances to it. One of the big differences in bringing a court action, I'll just call it a court action, whether it's federal or state, is the remedies you can get. And I'll talk more about remedies in the last question, but because when we talk about expectations, but that's a big difference. Is the powers of the courts obviously are much broader than the NAD, and you have the ability, the court can kind of fashion almost any form of relief, certainly monetary, injunctive, what have you. So that's a big difference, and we'll talk about some of the nuances to that. But a major consideration, of course, is cost. The cost of a court action is almost certainly going to be more than NAD. Some of the more complex NAD cases can get pricier, but rarely will they be as expensive or take as long as a federal court action, assuming that you're a plaintiff and you can take it all the way to some type of victory. That could cut both ways, though, because the costs are on both sides. So especially if you have a really good claim or really good argument, puts a lot of pressure on your opponent as well. And that could lead to settlement, because they can look in the mirror and they can decide, well, is it really worth me spending this much money fighting this claim? Do I really care about this advertising that I want to, spend all this money paying my lawyers? Even if I win, I just get to continue running that ad, but maybe I don't care that much. So it might be a way to sort of pressure the other side to drop it, particularly if you think you have a pretty strong claim. They can spend all that money and still, at the end of the day, lose and have to pay damages and what have you. Part of the reason why the costs are high, it's not at all because of the filing fees. The filing fees are actually quite cheap. It's only a few $100s, but it's more because of discovery and motions. And you have full discovery, you get extensive documents from the other side, and you have to turn over your own documents, and you have depositions, and there's third-party discovery. You could subpoena third parties and potential, possible consumers, depending on the circumstances. Certainly experts is a big deal in false advertising litigation in court. Surveys for consumer deception, consumer impressions, those are all a big part of it. Another big consideration is you can go in and get a TRO, a temporary restraining order, or a preliminary injunction. So this part could actually be very quick. Also could be expensive because it almost is like a mini trial that could happen right away, but you can go in and get get an injunction right at the beginning, potentially to stop the competitor from continuing the claims during the pendency of the case if you meet certain standards. Another consideration is that unlike NAD, these proceedings are public. The court's public, the filings are public with very limited exception. So that's something that might be a very good thing if you want to really draw this out. And, although the NAD decision itself is public, the NAD will issue a press release. The parties are not expected to promote those decisions generally with their own advertising or their own promotions, whereas in court, there's really no restrictions on that generally. If you get a good result, you're free to, promote it as much as you want, talk to the press, what have you. And one last consideration, and then I'll turn it back over so we could talk about some of the other jurisdictions, is in this type of circumstance where you have a competitor claim, but they're not directly targeting your product, they're really just promoting their own product in a false or misleading way. you do need to show injury to have standing as a plaintiff. And sometimes that is where, and this is kind of getting into a little bit of inside baseball, the nuances, but that can be that could be tricky in certain Lanham Act claims if you're not actually referenced by the other side, and it's a big market with a lot of competitors, to show how you were necessarily harmed by the competitor's statement about their own product. Depending on the court, there's a lot of different cases going different ways on that, but that could be another hurdle you'd have to overcome, and you have to figure out how to show. And there are ways to do it, but you have to basically show how you were hurt by the competitor's statements.
Very interesting, Craig. Thank you very much. And now moving to Mexico. What about you, Sebastian? How would you handle these disputes in Mexico?
Okay, so I'll start with the IP option, which is probably the most popular one, being that the action is initiated before the Mexican PTO. The authority would analyze the content of the probable infringing advertising following the criteria contained in the IP law, and then it will issue a resolution declaring if the content is indeed an unfair practice or not. In this action, the plaintiff would need to submit evidence of the materials considered as misleading, and the defendant would have chance to prove and present evidence to discard these allegations. The resolution could later be used to initiate civil actions to obtain monetary damages, with reinforced arguments being that one of the entities specialized in resolving these matters has already ruled on it. As mentioned before, the client would need to have a right that has been affected by these unfair practices to initiate this action. Now, as of the civil action, the affected party could initiate the procedure against the competitor for commercial practices, which will be resolved in a civil court. I can tell you that this would be the best scenario if what the client is looking for is to be awarded with monetary damages. The only issue with this line of action is that in the event of you're filing a civil procedure, if an IP action is initiated, for example, a non-use cancellation action, a nullity action against a trademarks related with the civil claim, then the civil procedure would be suspended until the IP procedure is resolved. Therefore, it would take much more time than expected. And as for the last action that is held before the Consumer Protection Agency, it's recommended only when the client is looking for the removal of the ad campaign, since, as mentioned before, the party filing the claim would not be involved in the procedure. Therefore, in this line of action, monetary rewards would not be available. Only an administrative fine could be imposed to the infringing party. So in conclusion, although in Mexico, it's legal to carry out comparisons between products or services, it's important to consider that these actions could be subject to an analysis from our authorities, and they must not fall into assumptions to be false or to be exaggerated. And if the advertiser fails to demonstrate in any of these procedures that their actions fall into this assumption, then these actions would be definitely considered as misleading advertising. And that's why many Mexican companies are very cautious with their advertising materials. Finally, there's also this ongoing debate in Mexico whether the Consumer Protection Agency resolutions are required to start an IP actions before the Mexican PTO. However, Mexican High Court has been established that Mexican PTO is entitled to resolve these unfair competition matters without the intervention of the agency. And finally, it should be considered that any of these actions would take at least 10 to 12 months to resolve.
Okay, thank you. So you you discussed about outcomes a bit when you refer to punitive to damages and monetary damages. So let's move on and discuss a bit the outcome and what could the client, the advertiser, the plaintiff expect at the end of the day. As far as France is concerned, if you want to get awarded monetary damages, you definitely would have to go before civil courts. But unlike some jurisdiction, we do not have the principle of punitive damages in France. The monetary damages aimed at compensating the prejudice, loss of sales, loss of consumer, reputation damages, but it must be proven. It's not a sanction per se. You need to evidence with figures sometimes that you have lost sales and consumers. So it's that's why it might be a bit difficult, and in particular when you have to prove that there is a link between the wrongful misconduct and the consequences on your business. So that's why sometimes when it's possible, because it's for sure cheaper and faster, some advertisers tend to go in and to file a complaint with a self-regulatory jury. And but the differences are that the jury does not have the power to fine advertisers who breach the SRO's recommendation. And whichever the outcome is, the decision of the jury will be published on the website, so that the main difference with the Canadian system, where I understand that everything remains confidential, whereas in France, if you want to damage the reputation of your competitor, you should have a think at this specific procedure, because it's a name and shame sanction. So that's the key information, key item that I wanted to address and to share with you. And turning to Fadi, could you say a few words about the outcome in Canada in connection with the respective actions that you would recommend?
Yes. So assuming that you've gone in front of ad standards, and assuming that the ad dispute panel maintains or sustains the complaint, the defendant advertiser, the losing party, will be required to either withdraw or amend the advertising in such a manner as to comply with the ad dispute panel's decision. So that's important, because the decision may be slightly different than what you're coming at as a complaining party. And not the procedure in front of ad standards is not designed to punish the advertiser, and does not provide for the award of damages. So, and the complaining party bears the cost of filing the complaint. So there's no mechanism to recuperate the costs. Now, a complaint in front of the Competition Bureau. So the Competition Bureau may obviously investigate, discontinue the investigation, seek to negotiate a settlement with the target of an investigation, or commence formal legal proceedings based on its own investigation or based on the complaint, right? So you could refer the matter for prosecution or make an application to the Competition Tribunal for an order. Now, the terms, assuming there's a settlement, the terms of the negotiated settlement may vary according to the case, obviously, but will commonly include negotiated penalties, an agreement to stop the conduct that violates the act, a commitment to adopt or revise the company's competition law compliance program, and some reporting obligations to the Competition Bureau. The filing of a complaint at the Competition Bureau is cost-free. Now, whether you've negotiated a penalty or contested it all the way to the tribunal and gotten ordered a penalty, the orders can be also to cease the activity, publish a corrective notice, or pay an administrative monetary penalty. On the first occurrence, individuals are liable to penalties of up to $750,000, and corporations are liable to $10 million. For subsequent occurrences, the penalties can increase to a maximum of $1 million for individuals and $15 million for corporations. Just to give you some examples that I pulled off the Competition Bureau website, because all of this is public, on January 6th, without naming names, but it's an issue of single-use coffee pods. where the allegations of false or misleading and environmental claims about the recyclability of single-use coffee pods. The company agreed to pay $3 million penalty, donate $800,000 to a Canadian charitable organization, and pay $500,000 for the cost of the Bureau's investigation. That was based on a consent agreement. So another really quick example, telemarketing online business directories. Sorry, no, not this one. Online flight booking services. That was a big one at the time. The company agreed to pay $5 million in penalty, and two company directors have agreed to penalties of $400,000 each. That was also based on a consent agreement. Last example I'll give you. So January 28, 2021, this was a company pleaded guilty. So they took it further, pleaded guilty to operating a deceptive trial offer scheme that trapped consumers into monthly subscriptions. It's not really deceptive advertising in the sense where it's not a comparative claim, but the company was fined $15 million and is subject to a 10-year court order prohibiting it from any direct or indirect involvement in promoting deceptive trial offers. So these are just recent examples, and by recent, I'm not talking months, I'm talking the past few years. Punitive damages, there isn't, it's penalties. It's not punitive civil damages. So you can't get that unless you're in a consumer. But here we're not talking about consumer law. Civil trials, you can get injunctive orders. You can get preliminary injunctions, interlocutory injunctions. You can get damages. You have to prove all the elements of damages. You have to prove that it's very similar to what Craig said. If you're a complaining party or a plaintiff, you have to show how that deceptive marketing actually caused you damages, and that's a tough causal link to prove. Just because how you're going to make it. That's basically it for Canada. Thank you for the time you gave me.
Thank you, Fadi. And is it possible to get monetary damages, Jaime, in Dominican Republic?
Monetary damages, no, and with the damages here in the Dominican Republic is as the judge would like to see it, and there is no precedent of what are the rules, what are the line to follow on that. And please remember, Caroline, that our court system is almost the same as last century court system in France, because it comes from there. So we have to prove and show evidence of whatever you said before, lost clientele and all that. Almost the same thing as France. And with pro competencia, we will have the fastest way to receive a decision on either if it's unfair or not. If time is of the essence, and please do not worry about time with the courts, because you want to know when it will end. So please don't pay attention to time. And in consumer protection, yes, it will be kind of easy to have the decision also in less than a year.
Thank you, Jaime. And for the US, Marc and Craig, do you want to add say a few words about the outcomes?
Sure, I'll go real quick for the NAD. As I said before, for the NAD, there's no monetary damages available before the NAD, so that would be a reason if that's a motivation to go to court. The reason to do the NAD route really is speed and cost. The NAD decision will happen typically within less than a year. If it's swift, it will be 20 business days. If it's standard, 4 to 6 months. If it's complex, it'd still probably be less than a year. Craig can talk about how long a court action will take, but you cannot get monetary relief or attorney's fees. If the advertiser doesn't comply, the NAD can refer it to the FTC, who can seek fines, but it's up to the FTC then to proceed with that action, and it can decide not to proceed. With that, I'll let Craig talk about the federal court.
Thanks, Marc. I know we're pressed for time, so I'll just try to go through pretty quickly. I mentioned, the kind of a whole panoply of potential remedies are available in court. You can get actual damages if you could show how you were harmed, or also instead of, or sometimes related to actual damages, you can also get disgorgement of profits under the Lanham Act. So you not just, instead of showing how your sales were harmed, if you could show that your competitor increased their own sales through the false or misleading advertising, you might be able to get a percentage of that as a punishment. There's sometimes the availability to treble the damages in certain circumstances or heighten the damages, but for the most part, you're looking at actual damages, disgorgement, not really punitive, so to speak. There's injunctive relief, which could take many different forms. It could be corrective advertising. It could be ceasing advertising. And in terms of the costs, for the most part, the U.S. system, everyone bears their own costs. There is a possibility of recovering attorney's fees. And when I say costs, I'm really talking about attorney's fees. There's like other types of costs that are recoverable, but those are a fraction of the total of what fees will cost you. And there's the possibility in an exceptional case to get attorney's fees, but that's definitely not the norm. And finally, one other thing you might expect, as Marc noted, it definitely will take longer. It could take a year or two or longer before you get a decision if you don't settle. And if you don't settle and it goes to trial and there is a decision, there's also the possibility of an appeal if you go to court. So it could go to an appellate body. They could remand it. They can change the decision. You could start all over again. So it can be a lengthy process, depending on where you are in the stage if you don't settle.
Okay, thank you, Craig. And Sebastian, do you have a few words about, for instance, who will be at the cost in the various system? Or?
Yeah, I'll be quick. The problem with punitive damages in Mexico is that the ones that are established in the law are very difficult to quantify regarding the economic or image prejudice. Therefore, even if the case is won, the awarded monetary damages would be very uncertain, being that the plaintiff will have to evidence a fault or a prejudice and the link between the infringing party actions and its supposed consequences. These actions would take a long time to quantify and resolve. So in the main part, the removal of the content and the administrative fines are usually the most common outcome to receive in Mexico. And I think that's it for Mexico.
Thank you, everyone. So let's move on to some questions. I know we are running a bit out of time, but if you have some questions, I'm just looking at the chat and Q&A box.
Well, just while we wait, if there's any questions, I thought one point that is worth mentioning in this kind of thing is you've got to get your own house in order as well, because otherwise you end up with competitor complaints. You end up in sort of tit for tat issue sometimes. You make a complaint, they make a complaint, and it becomes an industry-wide issue, and then it attracts more attention as well. So there is a sort of issue of that, and there's even been some cases where they've sort of backfired as well, where a party has complained about their competitors' advertising, and the complaint has not been upheld. And so essentially it's a big bit of publicity that says that the advertising was true and it is the best, it is the leader, it is whatever. So I just thought to mention this.
Thank you, Oliver. I'm struggling a bit to see if there are other questions. I went through the chat box, but I think if you want to add something or some tips or I think like in France, definitely publication is something which can be used as a weapon against a competitor, whereas I understand that in the UK and in Canada, at least for self-regulatory system, it might be a bit different. So it's interesting to see that depending on the purpose, on the expectation of the clients, we may recommend different type of actions. So it's very interesting, and I know that we have some similarities as well. For instance, in Mexico or Dominican Republic, in civil courts, you have to prove the prejudice and the link between them. So as I said, it can be a bit tricky sometimes. Yeah.
Caroline, I think that the reason why we like the confidentiality part of it is that I don't know what the situation for class actions or consumer class actions in France is, but I can tell you in Canada it's very, very active, and it's even more so, I think, in the States. So anytime there's a complaint at the Competition Bureau, you can expect class counsel across the jurisdictions in Canada to pounce on it, look at the documents, and then start suing in civil courts on behalf of consumers, which complicates things. So we like to keep stuff like that out of their hands as much as possible, and that's a big reason why companies would rather stay within, for example, ad standards than filing complaints and becoming that complaint war that my friend in the UK was explaining earlier.
Yeah, well, that's very interesting. Yeah, no, definitely. Yeah, but in France, when you want to negotiate, it's discussion, sometimes lawyer to lawyer conversation, and then you can reach an agreement and you can ensure that everything keeps confidential. And if in the end no agreement is reached, you can go in court and nothing will be disclosed in front of the court, even if one of the party admitted that it did a wrongful misconduct. And so that's why confidentiality is very important in France when dealing between lawyers. But we do not have this confidentiality principle before French civil courts, but even in front of the SRO's juries, because in the end, whenever the decision is positive or negative, it's published. So in the end, it could backfire with the plaintiff if the SRO's jury confirm that the ad is compliant and does not breach the code. So it could backfire, and it could be difficult for the plaintiff in the end because it will be published. So you need to be sure of and assess the case with lawyers before moving forward. That's where we are. So if we have no questions, I would like to thank you, the panelists, for taking the time to be so clever and be so clear about the legal system in your respective jurisdiction. Thank you for attending this session, and you can find out some information on the GALA website, GALA blog, and do not hesitate to reach out if you need specific answers to specific questions. We would be happy to help you. So thank you. Have a good day. Have a good evening, and see you soon. Thank you.
Thank you.
Bye.
Bye.
Thank you. Bye.